I want to walk you through the history of how Congress has shaped our immigration system over the past 70 years. Not through the lens of today's politics, but through the actual historical context. What problems lawmakers were trying to solve, what the national debates were at the time, and how both parties repeatedly came together to pass these laws. This is important because many elements of our current immigration system that seem controversial today were established through overwhelming bipartisan votes, signed by presidents of both parties, and reflected the consensus of their time. Let's start at the beginning. In 1952, America was gripped by Cold War anxiety. The Soviet Union had detonated its first atomic bomb. China had fallen to communism. Senator Joseph McCarthy was holding hearings claiming communist infiltration of the government. The Korean War was raging. Immigration policy hadn't been comprehensively reformed since 1924. The existing system explicitly barred Asian immigration and used racist national origin quotas heavily favoring Northern Europeans. But it was fragmented, outdated, and had no systematic deportation procedures. The restrictionists, led by Senator Pat McCarran, a Democrat from Nevada, and Representative Francis Walter, a Democrat from Pennsylvania, argued that America faced an existential threat from communist infiltration. They believed the immigration system needed to prioritize national security above all else. McCarran famously said the nation must be protected from a flood of undesirables, and that the communist movement in the United States is an alien movement. The liberalizers, led by President Harry Truman and Representative Emanuel Seller, also a Democrat, wanted to abolish the racist national origin quotas entirely. They argued these quotas damaged America's relationships with allies in Asia and Africa and contradicted our fight against Soviet totalitarianism. The McCarran-Walter Act was a compromise that satisfied neither side completely. It removed racial bars to immigration and naturalization. For the first time, Asians could immigrate and become citizens, but maintained national origin quotas favoring Europeans. Created the modern administrative structure for immigration enforcement, civil removal proceedings, immigration judges within the Justice Department, and enforcement authority. Established that deportation would be a civil administrative proceeding, not a criminal prosecution. Gave immigration officers authority to arrest based on reason to believe someone was deportable, a lower standard than criminal arrests. Provided no right to government-appointed counsel in removal proceedings. President Truman vetoed the bill, calling the national origin quotas a slur on the patriotism, the capacity, and the decency of a large part of our citizenry. He thought it didn't go far enough to eliminate discrimination, but Congress disagreed. On June 26, 1952, the Democratic-controlled House voted 278 to 113 to override Truman's veto. The next day, the Democratic-controlled Senate voted 57 to 26 to override. Think about that. A Democratic Congress overrode a Democratic president's veto to establish what would become the foundation of our current immigration enforcement system. The vote was genuinely bipartisan. Both Democrats and Republicans voted to override. The law reflected the Cold War consensus that national security required a systematic, enforceable immigration system, even if it meant fewer protections for individuals facing deportation. Fast forward 13 years to 1965. America had changed dramatically. The civil rights movement had transformed American consciousness. In 1964, Congress passed the Civil Rights Act. In 1965, the Voting Rights Act. The same moral logic that rejected discrimination against Black Americans at home made the racist national origin quotas in immigration law increasingly indefensible. America was also competing with the Soviet Union for influence in the developing world. Asia, Africa, Latin America. How could we claim moral leadership while our immigration law explicitly favored white Europeans over everyone else? President Lyndon Johnson made this connection explicit. In his 1964 State of the Union, he said, "We must also lift by legislation the bars of discrimination against those who seek entry into our country. We should not be asking, 'In what country were you born?'" The debate wasn't about whether to reform immigration. There was broad consensus that the national origin quotas had to go. The debate was about what would replace them. The Hart-Celler Act, sponsored by Senator Philip Hart, a Democrat from Michigan, and Representative Emanuel Seller, the same Democrat who had opposed the 1952 law, finally abolished the national origin quotas. Instead, the law created a preference system based on family reunification, 75% of visas, Skilled employment, 20% of visas. Refugee status, 5% of visas. Critically, the law maintained the administrative structure from 1952. Civil proceedings, immigration judges, and the Justice Department. No appointed counsel, lower burden of proof. Why? Because these weren't seen as bugs, they were seen as features. Immigration was understood as fundamentally different from criminal law. The question wasn't whether someone committed a crime and deserved punishment. The question was whether someone had legal status to remain in the country. The vote was overwhelming and bipartisan. House 320 to 70, 82% approval. 202 Democrats voted yes, 60 voted no. 118 Republicans voted yes, 10 voted no. Senate 76 to 18, 81% approval. 52 Democrats voted yes, 14 voted no. 24 Republicans voted yes, 3 voted no. President Johnson signed it at the Statue of Liberty, calling it a correction of a very deep and painful flaw in the fabric of American justice. Interestingly, Johnson and congressional sponsors downplayed the law's likely impact. This bill will not reshape the structure of our daily lives, Johnson said. Senator Ted Kennedy assured Americans it would not upset the ethnic mix of our society. They were spectacularly wrong. The law opened immigration from Asia, Latin America, and Africa. Immigration that had averaged 250,000 per year in the 1950s would eventually reach over 1 million per year. The face of America would change dramatically, but that wasn't the intent in 1965. 15 years later, America confronted a different crisis. The Vietnam War ended in 1975 with the fall of Saigon. Hundreds of thousands of Vietnamese, Cambodians, and Laotians fled communist regimes. They came by boat, the boat people, risking death at sea to escape. Between 1975 and 1979, about 300,000 refugees arrived in the United States through presidential action. Because existing law had no systematic refugee program, Congress admitted them through ad hoc measures, special bills for specific groups. Senator Edward Kennedy saw this as untenable. America needed a permanent, predictable refugee system that could respond to humanitarian crises without requiring new legislation each time. There was another problem. The legal definition of refugee was ideologically biased. It covered people fleeing communist countries or Middle Eastern dictatorships but didn't align with international standards set by the United Nations. The Refugee Act of 1980 adopted the undefinition of refugee, someone with a well-founded fear of persecution based on race, religion, nationality, political opinion, or social group, set an annual cap of 50,000 refugees, created emergency procedures allowing the president to exceed the cap during crises, established the Office of Refugee Resettlement to help refugees integrate, required annual consultation between Congress and the president on refugee numbers. This wasn't controversial. The bill reflected a broad humanitarian consensus. Senate 88-0, unanimous. The House also passed it overwhelmingly, 328-47 in an earlier vote, then 211-195 in the final conference report, closer because of technical disagreements, not philosophical opposition. President Jimmy Carter signed it on March 17, 1980. Think about that, unanimous support in the Senate. Both parties agreed that America had a moral obligation to provide refuge to people fleeing persecution. The irony? Within weeks, the Mariel boat lift brought 125,000 Cubans to Florida, straining the new system immediately. But the principle held: America would be a place of refuge. By the mid-1980s, a new problem had emerged: illegal immigration. An estimated 3 to 5 million people were living in the United States without legal status. Most had entered illegally or overstayed visas to work. The existing system had no effective way to control this. Employers openly hired undocumented workers. There were no penalties. The labor market was the magnet drawing illegal immigration. Congress spent 4 years debating solutions. Similar bills passed the Senate in 1982 and 1983, but died in the House amid lobbying from Hispanic groups, farm organizations, and businesses. Two principles emerged. You can't deport millions of people who've built lives here. You can't let this continue without addressing the root cause. The solution was a grand bargain. The Immigration Reform and Control Act, known as IRCA or the Simpson-Mazzoli Act, had two parts. The carrot: amnesty for undocumented immigrants who'd been in the country since before January 1, 1982. Special Agricultural Worker Program for farm workers. Result: 2.7 million people eventually gained legal status. The stick: employer sanctions, fines up to $10,000 per unauthorized worker. Required employers to verify work authorization and increased border enforcement funding. Senator Alan Simpson, a Republican from Wyoming, and Representative Romano Mazzoli, a Democrat from Kentucky, crafted the compromise. The vote was bipartisan. House 238 to 173. Senate 63 to 24. President Ronald Reagan signed it on November 6, 1986, calling it the most comprehensive reform of our immigration laws since 1952. Reagan said, "Future generations of Americans will be thankful for our efforts to humanely regain control of our borders and thereby preserve the value of one of the most sacred possessions of our people, American citizenship." The consensus was clear: combine compassion for those already here with enforcement to prevent future illegal immigration. Did it work? The amnesty succeeded. 2.7 million people gained legal status. But employer sanctions failed. Document fraud was rampant. Employers used subcontractors to avoid liability. Illegal immigration resumed by 1990. 4 years later, Congress revisited immigration again, but this time the focus was legal immigration. American businesses argued they couldn't find enough skilled workers: scientists, engineers, computer programmers. The existing system gave too few visas for employment-based immigration. At the same time, countries that had been shut out by the old national origin quotas, particularly Ireland and African nations, had very limited immigration opportunities under the 1965 family-based system. The Immigration Act of 1990, introduced by Senator Ted Kennedy, increased overall immigration from about 500,000 to 700,000 annually, created 5 employment-based visa categories with 140,000 annual visas for skilled workers, established the diversity visa lottery giving visas to countries underrepresented in immigration, expanded the definition of aggravated felony to include more crimes that trigger automatic deportation. That last point is important. This was the beginning of using immigration law as a tool for crime control. Permanent residents who committed certain felonies would lose their status and be deported. The list started small: murder, drug trafficking, firearms offenses, but it would grow dramatically. The vote was overwhelmingly bipartisan. House Conference Report 264 to 118, 69% approval. Senate Conference Report 89 to 8, 92% approval. President George H.W. Bush signed it on November 29, 1990, saying it recognizes the fundamental importance and historic contributions of immigrants to our country. Notice the pattern. Both parties wanted more legal immigration for different reasons. Republicans for skilled workers to help businesses, Democrats for family reunification and diversity. Now we come to the pivotal year that created most of what's controversial today, 1996. By the mid-1990s, immigration had become politically charged. Several factors converged. First, crime. The early 1990s were the peak of violent crime in America. The tough on crime movement dominated both parties. In 1994, Congress passed the Massive Crime Bill, supported by both parties, with harsh mandatory sentences. Immigration became linked to crime. News stories highlighted cases of permanent residents committing crimes after serving prison time, then being released back into communities instead of deported. Second, terrorism. In 1993, terrorists bombed the World Trade Center. One planner was an immigrant who'd applied for asylum. In 1995, Oklahoma City was bombed, though by domestic terrorists it raised security fears. Third, border security. Illegal border crossings were increasing. The 1986 employer sanctions had clearly failed. Border states, particularly California, faced fiscal pressure from undocumented immigration. Fourth, welfare reform. Congress was reforming welfare, cutting benefits. There was sentiment that immigrants shouldn't receive public benefits. Fifth, political dynamics. 1994 was a watershed election. Republicans won control of both chambers of Congress for the first time in 40 years. They had a mandate for tough policies. The debate became, how do we secure borders, remove criminal immigrants, prevent terrorism, and reduce illegal immigration? The answer was IRERA, the Illegal Immigration Reform and Immigrant Responsibility Act. IIRIRA was the most comprehensive restriction of immigration in modern American history. It dramatically expanded enforcement, created expedited removal, allows border agents to deport people immediately without a hearing before an immigration judge, mandated detention without bond for immigrants with certain criminal convictions, added the 3-year and 10-year bars if you're in the U.S., illegally for 180 days, you're barred from returning for 3 years. If here for a year, barred for 10 years. Authorized increased border security, more agents, more fencing, more technology. Dramatically expanded deportation. Massively expanded aggravated felony definition, from 5 offenses to 21 plus categories, including many misdemeanors with 1-year sentences. Made aggravated felonies retroactive. Crimes committed before 1996 now triggered deportation. Eliminated 212C relief. Previously, immigration judges had discretion to waive deportation for long-term permanent residents with equities in the U.S. This eliminated that discretion. Made permanent bars automatic for many offenses. Dramatically restricted judicial review. Limited federal court review of immigration decisions. Eliminated habeas corpus for many immigration detainees. Restricted appeals of discretionary decisions. Here's what's extraordinary. This passed with overwhelming bipartisan support in a Republican Congress with a Democratic president. House Conference Report, 370 to 37, 91% approval. 182 Democrats voted yes. 188 Republicans voted yes. Senate Conference Report, 84 to 15, 85% approval. 37 Democrats voted yes. 47 Republicans voted yes. Total 219 Democrats supported IIRA across both chambers. President Bill Clinton signed it on September 30, 1996, saying it would strengthen the rule of law by cracking down on illegal immigration at the border, in the workplace, and in the criminal justice system. Why such overwhelming support? Because in 1996, this was the consensus. Both parties agreed. Borders need to be secure. Criminal immigrants should be deported. Illegal immigration should have consequences. The system needed teeth. The law reflected the tough-on-crime mentality of the era, applied to immigration. Just as both parties supported harsh criminal sentences, both parties supported harsh immigration consequences. What they didn't fully anticipate were the human consequences. Families torn apart by deportation for crimes committed decades earlier. Permanent residents with deep American ties barred from returning after traveling abroad. The elimination of judicial discretion leading to harsh results in sympathetic cases. 9 years later, America was living in a post-9/11 world. The September 11, 2001 terrorist attacks killed nearly 3,000 people. The 9/11 Commission investigated and issued recommendations. One was clear: the hijackers had exploited weaknesses in identification systems. Some had fraudulent documents. Some had overstayed visas. The Commission recommended the federal government should set standards for the issuance of birth certificates and sources of identification, such as driver's licenses. There was broad consensus that identity security needed to be strengthened. The debate was over how. What Congress did, the Real IT Act, did 2 things. First, immigration restrictions. Increased asylum standards, requiring more corroboration of claims. Gave immigration judges broader authority to assess credibility. Limited judicial review further. Second, identification standards. Required states to verify immigration status before issuing driver's licenses. Set federal standards for state IDs to be used for federal purposes like boarding airplanes. The act was controversial in how it passed. Attached as a rider to a must-pass military appropriations bill, avoiding extended debate. But the support was overwhelming. House Conference Report, 368 to 58, 86% approval. Senate Conference Report, 100 to 0, unanimous. President George W. Bush signed it on May 11, 2005. Again, notice, unanimous Senate support. After 9/11, both parties agreed that security required better identification systems and stricter immigration procedures. The next year, Congress passed one more enforcement measure. Illegal border crossings remained high. Border states were frustrated. There was a sense that the physical border was porous and insecure. The debate was straightforward. Should we build physical barriers along the southern border? The Secure Fence Act authorized 700 miles of fencing along the U.S.-Mexico border, additional vehicle barriers, checkpoints, and lighting. Increased use of technology, cameras, satellites, unmanned aerial vehicles. The vote was overwhelmingly bipartisan. House 283 to 138. Senate 80 to 19. President George W. Bush signed it on October 26, 2006. Here's what's notable. 26 Senate Democrats voted yes, including Barack Obama, Hillary Clinton, and Chuck Schumer. Why? Because in 2006, supporting border security was mainstream in both parties. As Obama later explained, he saw it as a lesser evil compared to harsher House bills that would have criminalized undocumented immigrants. The fence was seen as physical security, not immigration policy. Both parties could support making the border more secure. Let me bring this home. Over 7 decades, Congress has repeatedly acted on immigration with overwhelming bipartisan support. 1952, Democratic Congress overrode Democratic President's veto to establish the foundation of civil removal proceedings and enforcement authority. 1965, both parties abolished racist quotas with 82% House support and 81% Senate support. 1982, Senate unanimously established refugee protections. 1986, Republican President and Democratic House passed amnesty for 2.7 million people. 1990, both parties expanded legal immigration and created employment visas. 1996, Republican Congress and Democratic President passed the most restrictive enforcement laws in history, with 91% House support and 85% Senate support. 2005, Senate unanimously passed post-9/11 security measures. 2006, Senate passed border fence with 80% support, including Democratic leadership. What's the pattern? The pattern is this. Congress has repeatedly determined that immigration enforcement should be civil, not criminal, because it's about status, not punishment. Administrative, not judicial, because it's an executive function of border control. Enforceable with consequences, including detention and bars to re-entry. Subject to limited court review, to maintain executive control over foreign policy. These weren't partisan decisions. They weren't violations of constitutional principles. They were democratic choices made by large bipartisan majorities responding to the concerns of their time: national security in 1952, civil rights in 1965, humanitarian crisis in 1980, crime in 1996, terrorism in 2005. The Supreme Court has repeatedly upheld this framework as constitutional. Understanding that history doesn't tell us what we should do now, but it does tell us something important. The question isn't whether immigration enforcement is constitutional. The question is whether it's the right policy for America today. And that's a question for all of us, and for Congress to answer. So here's the question we face today. When we debate immigration policy in 2025, are we debating whether these policies are legal? Because they clearly are, established by Democratic majorities, signed by presidents of both parties, upheld by courts for decades. Or are we debating whether these policies are wise? Whether they balance enforcement and compassion appropriately? Whether they reflect our values? Those are legitimate debates. Congress has the power to change these laws, just as it's changed them before. If there's a Democratic consensus that the system is too harsh, Congress can provide more protections, create more pathways to legal status, limit detention, restore judicial review. But let's be clear about history. The current system wasn't imposed by one party or one president. It was built over 70 years by both parties responding to the challenges of their times: Cold War fears, civil rights imperatives, humanitarian crises, crime waves, terrorist attacks, border security concerns.